Good morning, everybody, and welcome to our June webinar, our last webinar of the financial year. We hope that you're surviving the end of financial year rush. This morning is going to be the first of a three-part series that we're hosting over the next couple of months on asset protection, having a look at strategies and then also having a look at how to defend those strategies if something happens with those assets. So first off, today we're going to be talking about having a look at personal asset protection. So if you have clients who have personally held assets, and most of them will have at least the home that's personally held, then having a look at strategies that can be implemented to protect those assets, and then also issues in relation to those strategies and the clawback provisions and so forth that we have to think about whenever we are implementing them. Our presenter today is Helen Gerard from our Brisbane office. Helen works predominantly with Paul McEnroth and Brett Hart, looking after clients up in Queensland. She does do a lot of this work for those clients, and she is going to take you through the presentation this morning. Just a little bit of housekeeping first. If you look over, you should have a function on the right-hand side with a few different boxes there. One is chat function. You can put questions in. Helen's more than happy to take questions. She will take them at the end of the presentation, but I'll moderate them and relay them to Helen at the end of the presentation today. So that's the chat function, or if you're just having other general issues, I'll be on the line to hopefully assist in terms of those general issues in relation to the software. You'll also see a files button over there on the right-hand side. It's on the right-hand side of my screen anyway. From that, you can download the papers from today. So you can download the presentation by clicking on that. If you don't get the chance to download it during the presentation, then we will be sending it to you in the feedback email as well that you receive at the end of the session. So I'll throw over to Helen now, who will start the presentation this morning.
So good morning, everyone. As Adrian mentioned, today we're going to be looking at asset protection for individuals. So broadly, we're going to be considering how individuals can insulate their assets from attacks by creditors, as well as what factors clients and practitioners need to take into account when responding to an attack if and when it does happen. So we're going to be considering what are the threats, how can we protect individually owned assets from attack, how we respond to those attacks, look at clawback periods, and a very brief look at what to consider from an individual asset protection point of view in the litigation process. All right. So in no particular order, clients are generally concerned with asset protection for bankruptcy and the family court primarily, along with a range of other disputes. So for bankruptcy, individuals are often concerned about whether an existing creditor can press them into bankruptcy. And from there, they're also concerned about the day-to-day and long-term impact of bankruptcy on their lives and their family lives, as well as whether the threat of bankruptcy is a realistic possibility or whether it's actually a likely reality. With divorce or any other type of spousal property settlement, due to the far-reaching power of the Family Law Act, an order by the family law or by a Supreme Court in any state can disrupt not only individually owned assets, but also assets owned in companies and trusts. So this is obviously an unpalatable outcome for stakeholders as well as the individual subject of the order. And finally, there are a number of other threats, such as those from shareholder and unit holder disputes, partnership disputes, deceased estate disputes, and director liabilities, which we have outlined in other papers. So we won't go through them in depth today. Not all of these represent an immediate asset protection threat, but similarly, they ought to be approached on the basis that those assets will be attacked at some point. So the question that we encourage clients to ask themselves when looking at asset protection is, what exactly is protecting my assets? So how do your structures, finances, administration of entities separate value out from risk of attack? So So if you're unable to separate assets from risk of attack, instead, is there a way that the assets can be protected from attack using strategies such as mortgages and PPSR, security interests, and so on? And for that, we, of course, use our secured debt strategy, which we've been using for about 25 years now with high levels of success. But before we go through that, we're going to have a quick look at what the traditional solution is. So the traditional solution involves transferring protected assets away from an individual into a safe haven entity. So this is generally a discretionary trust or a company which is wholly owned by a discretionary trust. The safe haven entity has to have limited exposure to risk. That is, it shouldn't have any commercial activity. It should be an entirely passive trust. So pros and cons for the traditional solution. Traditional solution does achieve asset protection, which is obviously the positive to it. However, it often does so with significant tax consequences, which makes the solution either unpalatable or simply impractical or unaffordable. Additionally, the clawback provisions that will apply to the secured debt solution will still apply to the traditional solution, so there's no change on that front. So our solution is our secured debt strategy. So asset protection can be achieved just as under the traditional solution by restructuring equity rather than moving assets to a safe haven entity. So by focusing on equity or ownership of value rather than asset ownership, it means that the tax consequences that are an issue under the traditional solution are avoided or eliminated. The same clawback provisions that apply to the traditional solution again will apply, and we'll have a look at them in a little bit. So when implementing a secured debt strategy, the process is to first identify the net equity of an individual, being the value of their assets less the value of any encumbrances over those assets. The individual will make a gift of money, usually via a bearer note, equal to their net equity to a newly formed discretionary trust. And this is that passive safe entity that we've been talking about. The discretionary trust will then loan the same amount of the gift back to the individual. This is a formalized paper loan, and as security for that loan, the individual will execute appropriate security in favor of the discretionary trust, generally in the form of mortgages over real property and PPSR security interests over any other sort of personal property. So as a quick case study, we're going to look at Margaret Gall, who is a surgeon, obviously quite a litigious career, and putting aside any professional indemnity insurance Margaret may have, we can have a look at what assets are exposed. So she has a family home with a market value of $3 million and a debt of $850,000. There is a discretionary trust which owns investment assets of shares. The income from that trust is distributed into a bucket company, and Margaret owns the shares in that bucket company personally. There are unpaid entitlements to the company from the trust of $2 million, and therefore the shares in the bucket company are worth $2 million. There is a commercial property which has a market value of $2.6 million with a debt of $200,000. And finally, the family trust also has a beneficiary account with $1.2 million in it that Margaret has access to. So from this, we can have a look at Margaret's net position of what is at risk. She has a net equity of $7,750,000. All of the assets are at risk, and this includes the assets in the family trust as a result of that beneficiary account. So we can then move on and say we'll recommend our secured debt strategy. So under secured debt, a new bloodline trust is established, and Margaret will make a gift via a bearer note of 7.75 million to that new trust. The trust in turn will loan that money back to Margaret personally, and in return it will take a mortgage over her home and the commercial property and PPSR security interests over the beneficiary account, as well as the shares in the bucket company. And our end result is the trust is a secured creditor of Margaret. Margaret's net equity, so her net position, has been reduced to nothing, and the loan is secured by mortgages over the real property and security interest over the shares and the beneficiary account. And most importantly, there is no tax as a consequence of the movement of this cash in the loan back. All right, and just back on the last case, I do just want to make a quick note on bearer notes. So we do get asked quite a lot of questions about promissory notes and whether they are legal. So it's important to understand the nature of a promissory note. So they are accepted legal tender in the same way a cheque is. So they're both considered bills of exchange and are defined in the Bills of Exchange Act, which is the Commonwealth Act from 1909. And the form of the note used in secured debt is what's called a two-party bill of exchange, whereas a cheque is a three-party bill of exchange, as it has the third party, which is the bank. All right. And now we're just going to have a look at existing mortgages. So we need to be mindful that if an asset we're seeking to protect, such as a main residence, which is often owned by an individual in their own capacity, does have a mortgage to a third party, like a bank, the strategy may result in a breach of our client's existing loan covenants. So for that reason, we should always seek the consent of the bank first. So the bank is normally satisfied provided the mortgage or charge they hold has security, but they often will require just a deed of priority between the trust and the bank, just confirming that the trust understands and acknowledges that the bank has the prior security on that property. So we deal with this quite a bit. It is rarely an issue. It doesn't make the process go any faster, but banks will generally accept what we're doing here in terms of asset security. All right. So we now have our secured debt in place for Margaret, and at this point we're going to be looking at what acts can unwind these gifts and bring that cash value back into Margaret's name. So first of all, we'll be looking at clawbacks under the Bankruptcy Act. So this includes undervalued transactions, transfers to defeat creditors, transfers to third parties, and you'll see I don't have a time limit in there, which is for a reason we'll discuss, and finally preference payments. So starting with section 120, which is undervalued transactions. This section applies where transfers of property are effected for no consideration or for less than market value consideration within a period of 5 years from the date of bankruptcy. However, this period, the clawback period, is reduced to 4 years if the petitioner can show that they were solvent at the date of the gift. Now, a transfer of property will include a gift such as a payment of money under secured debt. So the result is, if we continue to use Margaret as our example, Margaret has entered into secured debt strategy 4 years and 6 months ago. At the time that she made the gift to her bloodline trust, she was solvent to the extent of the gifted amount, and she also made a record of her solvency by talking to her accountant. And the date of the bankruptcy occurs then 4.5 years later. As Margaret was solvent at the time she made the gift, the trustee in bankruptcy is unable to recover the amount of that gift and unwind those transactions to bring them back into Margaret's bankrupt state. So for this reason, it's always our strong recommendation that clients should obtain a solvency statement from their accountant as evidence of his or her solvency at the time the gift was made to the safe entity. So moving on to the next section, section 121, which are transfers to defeat creditors. So this section enables the trustee in bankruptcy to set aside dispositions of property to a person where the main or predominant purpose is to defeat a claim of a creditor or for to prevent the property from being divisible among creditors. So this section does not have a time limit. However, it's also that this is a very difficult section for the trustee in bankruptcy to often prove. So the onus is on the trustee to prove that the main or predominant purpose of the transaction was to defeat a creditor. So this section will be relevant to a client where there is pending litigation or bankruptcy and a transfer is made. So in that case, the onus shifts to the donor, so the person making the gift, to prove that the disposition was honest and not for the purpose of defeating creditors, even in part, but for another purpose entirely. So in circumstances where they can prove that the entire reason was to benefit family members for estate planning or to obtain taxation benefits, you can get around section 121. But if you do have pending litigation or bankruptcy does appear to be imminent, that is going to be quite a high bar to get past the trustee in bankruptcy. Right, so moving on and having a look at section 121A, this is where a petitioner, so who's later become bankruptcy, has directed that consideration be paid to a third party instead of to themselves. And this section applies as where that payment is directed to another person, that is considered a gift by the trustee in bankruptcy from the now bankrupt petitioner to that other third person. So in terms of timeframes, it will depend which angle the trustee in bankruptcy is going for. If they're saying it is an undervalued payment, the 4 or 5 year timeframe will apply. If they're saying the transfer or direction to pay another person was an attempt to transfer to defeat creditors, then there is no time limit. And again, for section 121 there, the trustee in bankruptcy would have to prove that the main or predominant purpose for the direction of the payment to a third party was to defeat creditors rather than for some other reason. And finally, we have preference payments, which is section 122, which is payments favouring one creditor over another. So the trustee in bankruptcy can pull those payments back from those creditors and bring them into the property pool to be distributed amongst the secured and then unsecured creditors. This has a 6-month time frame and it captures market value payments of invoices to related entities. Now, quickly moving on and having a look at the family court. So in relation to the family court, the court will tend to look at the substance of a transaction, the nature of the asset, and who controls it. So trust assets which are not properly structured can become property of the marriage in a family law dispute, and this will often heavily depend on when those assets were moved into a trust, as well as on the control of that trust. So transactions that are made to defeat a spouse from having access to assets of the marriage will be set aside. And if we go on and have a look at the Family Law Act, section 106B, the court will consider transactions that are made to defeat a claim by a spouse will include where you transfer property to another person, company, or trust, where that transfer is either not for value or undervalued, where a sham mortgage is given over a property. So obviously legitimate mortgages are excluded from this, but mortgages between related entities and say from one party's parents over a property where they haven't actually received the equitable value back will be set aside, where one party has forgiven a debt, and the deposit of a passbook and withdrawal slip in consideration of advances. And that last one is really just dealing with control. So if any of these transactions are set aside, the court will add the money or asset, or potentially the value of the money or asset, back into the asset pool for division between the parties. And also don't forget about the state acts. So most states and territories have conveyancing acts and property law acts, which have no statute bar, where a party has transferred property to defeat a creditor for reduced consideration. And for our New South Wales-based practitioners, they need to be aware of the notional estate provisions of the Succession Act New South Wales, which is a fairly complicated area, but as a very basic summary, the notional estate provisions allow a court to unwind transactions made by a deceased person within 3 years of their death that have resulted in the property pool at death being depleted, and to add back in the value of those assets or the assets themselves to assist in satisfying a claim by an applicant under a family provision claim. All right, so moving on to litigation, as a very brief look, we're going to have a look at what you should consider in terms of where your secured debt is when litigation does occur. So the focus will be on enforceability, and so practitioners should always assume the worst case, that the litigation will be successful. Test your strategy, your secured debt strategy, or whatever other asset protection strategy you have in place, and assess that for its strengths and weaknesses. So the action plan will start with identifying which assets, entities, or compartments are compromised, identify which assets are safe, which may be exposed, and who the secured creditors are. What is the extent of watertight integrity, which really means where is our safe equity, and are there any other actions that you can take to better improve the security over your position? So the answers to these questions will determine whether there is equity in assets or actual assets which can be protected, and that will then drive consideration of measures available to reinforce integrity of those assets and the protection of the equity in them. So when considering defending asset protection strategies, you're looking first of all at your clawback periods. You're looking at control, which includes control of companies and of trusts. In terms of trust, you'll also be looking at who the default beneficiaries are. And finally, you want to look at who has rights to access what information. So when it's clear which assets are protected and which entities are protected and which are at risk, you should first of all consider those clawback periods that we've been over and make sure which of those are or aren't within the potential periods. And when looking at control of assets is often actually outside the reach of legislative provisions, even in relation to clawback periods. So the extent to which the control of companies and trusts is relevant will depend on the theatre of the dispute and also the terms of the structure, documents such as trust deeds and company constitutions. So, for example, trust deeds and shares in a company may be more vulnerable to a family court act than they may be to bankruptcy. So with companies, we can't assume the share rights for a particular class of shares is the same in this company as they are for others you may have dealt with for the same client, and you can't assume that the trustee for a discretionary trust is as strong as a purely discretionary trust, such as a bloodline trust, particularly if there are default beneficiaries who may have some entitlement to trust assets and income during the dispute. So the first step is always to examine your documents very carefully and to actually confirm what the rights are and not assume what rights are. So the existence of default beneficiaries in a trust is not necessarily fatal if the dispute is well managed and the trust is well administered. So in that regard, close attention should be paid to the balance sheet for a trust or company to determine the extent to which monies owed to or from related entities and whether those internal loans may compromise an asset protection position. You should always, in terms of rights to access information, be vigilant about requests for information from trustees in bankruptcy and opponents in a family court dispute or any other dispute. So those parties will often assume that simply because they're a party to the action, or they believe their party may be a controlling mind, they have a right to be entitled to know information about that entity. That's rarely the case, and a detailed knowledge of the law of the relevant theatre and of that entity will allow you to control the flow of that information more effectively. And so in summary, when considering asset protection in terms of litigation, the first step is that timing is everything. So you want to get past your clawback provisions as soon as possible to make sure your risk is separated from your assets, whether that's by actually moving assets or by doing secured debt, to pressure test your structures at the time or before a claim is made, so you can figure out where your weaknesses are. And as we've just spoken about recently, is that in terms of internal loans between companies, which have added some element of exposure that wasn't there before. And finally, act before it's too late. So the earlier secured debt or other asset protection is put in place, the better it is. If your client is at the point where they are approaching bankruptcy or about to be sued, then often it's too late to put effective asset protection in place to protect their assets. And that's it.
Okay, Helen, I've got a couple of questions here if you've got time to answer them. First question, how do you transfer assets to a protected entity without creating a loan back to the transferor, which could still be subject to attack and claim by creditors?
So I suppose you can just make a gift, but the problem is then what do you do with that asset without loaning it back? So the problem is if you own a house worth $2 million and you want to transfer the equity, unless you're getting something back in return, you're trying to shift money without actually shifting it. Sorry, I don't think I'm explaining this very well, Adrian, but effectively, unless you actually have the capital to transfer that asset outright, or you're willing to just transfer it and bear the costs, it needs to come back to you in the form of a loan, so you don't actually have to shift the asset or the funds.
I think the question's more the transfer itself, but I mean the short answer is if you do it by way of gift, there won't be a loan owed back to you. It doesn't get around those clawback provisions that you went into in terms of timing, but similarly, you're not achieving anything by transferring and having a loan back. You're getting outside the clawback provisions, but the loan is an asset. So the reason that we tend to do the gift of the value of the equity via the bearer note is so that we don't have any tax consequences. But all asset protection work for individuals is really about giving things away. So no matter what you do, whether it's giving the asset or giving things that undervalue, there will always be those clawback provisions that apply. Next one, Helen, is does the gift to the trust pose any problems under notional settler provisions?
If this is for the notional estate provisions for New South Wales Succession Act, then yes, it definitely does.
Yeah.
And that can be unwound. So again, you're looking at getting past that 3-year time period. I think it's extended to 4 years if they can prove the transfer was done to defeat a notional estate provision. So again, you're looking at having your documents done up showing the reason why it was done to dispute that.
Yeah. And in terms of the other notional settler provisions, just in case the query was in relation to tax aspects, it doesn't pose any problems under those, and the case law is clear that there's no issues there. Next one is, does Section 120 still apply within 4 years if you could prove you were solvent at the time of gifting and you gifted a lesser amount at that point in time?
I'm not entirely sure I understand the question. So is it that, if you gift an amount, so if you give anything away, if you can prove you were solvent at the time, then you're safe, I guess, within the 4 years. I'm not sure. Sorry, Adrian, could you say the second part of the question again?
I think probably first, just to clarify, the 4 years applies even when you're solvent. There's still that 4-year period. If you gifted a lesser amount at that point in time. So I think the question relates, and Roy, happy to, if you want to send in some clarification. Okay. I think it means if you gift less than what the value, less than what the asset is worth. So say if you had a home worth $1 million and you gifted 500,000. I mean, the short answer is 4 years would still apply in that circumstance because you're still giving things away.
Yep. So the gift is generally always undervalued. If it's a full value transfer where the trust has purchased it, then it's safe by virtue of the fact that Margaret has received due consideration.
In terms of next question, is this something that we need to do every year, or is it a one-time exercise if we're doing the secured debt?
So with secured debt, we'll tell clients to come back if you have a more significant change in your net equity. So it's not necessarily something you have to do every year, but it's definitely something you should revisit perhaps every 3 or 5 years to say, well, my net equity has actually increased by $80,000, $100,000, $200,000. Let's make a further gift and loan back at that time.
Next one for you, Helen, is Section 90C of the Family Law Act effective before litigation starts?
I'm not sure. So those are the transactions that if a party to a family law proceeding can come ahead with and say, my husband or wife is saying that they have forgiven a gift of X amount. I want that to be drawn back into our estate. Then the court can say yes or no. So, I mean, you can do anything you want right up until you get a court order made against you requiring you to pull that back in.
How's your accounting these days, Helen?
Pretty rubbish.
How will you show that Mark, I'm assuming you're talking about the secured debt process. How will you show it on the balance sheet? So it is that,
so you make a gift of your net equity of $1 million, if that's physically how it is. So that gets marked down as a gift in the trust account books, and it has $1 million and gets immediately loaned back out on the same day.
Yeah. So that goes in as capital contributed to go in the equity section. And then in essence, it's changed via your journals to a loan. So it's an asset of the trust of the $1 million, but it's loaned to Helen, for example.
Yeah.
Last one for now. In your example, should Margaret pay the bloodline trust for the future use of the assets?
It would depend on the asset. Generally, no. I mean, the assets will remain in Margaret's name, so she will have ownership of them. So think of it the same way if you get finance to buy a car or a mortgage to buy a house, it should be treated the same way. You own that asset and you can use it as you wish. You don't lease it necessarily. So you don't really need to pay for the equity in it. You don't need to pay for the ongoing use of it. You just need to comply with whatever the terms of the mortgage or loan agreement are.
Yeah. Okay, and then we've had a flurry of further questions, Helen. So don't dash out of the room. It's good. Keep them coming. Is the 4 or 5 year clawback apply? Does the 4 year or 5 year clawback apply for a cash gift to a low income earning spouse? For example, loan in high risk name professional and offset account in low risk spouse.
So if you can raise one of the defence, so if it was for some other purpose, like a cash gift to a spouse, and generally things with cash gifts to spouses may have some other tax benefit. So, a tax gift to a spouse's superannuation fund or some other reason. But if you can show that the main or predominant purpose wasn't to avoid a creditor, or was for some other reason, then you can disprove what the trustee in bankruptcy is trying to say. But again, it's always going to depend on the particular factors of each gift, of each person, of the circumstances. The trustee in bankruptcy would have to prove to a court that it was done for a particular reason. So if you can show to the satisfaction of the court that you did it, to provide for your spouse who earns less income, then it will be more likely that the court will accept that. So you're really looking at what evidence you can show, and if you can't show any evidence, what evidence the trustee in bankruptcy can show.
I think also you could rely on principle of advancement, which was recently revisited in a case called Bosanak, where it's a very old common law principle that says if a husband is giving funds to a wife, for example, in relation to the property, that doesn't mean they want an interest in the property. Only works one way, unfortunately. So as I said, it's a fairly old concept, but it's still valid. So you would also have some protection in relation to that for this sort of scenario.
Yeah. And it's going to be a lot easier, obviously, giving cash gifts to spouses than it will to, a brother or some other person not as closely related.
For a property about to be purchased by a professional, actually, I'll take that question offline, Michelle. So we'll send you a response on that separately. Sorry, I didn't read it through fully. What implications does all this have on Margaret's ability to borrow in the future?
Well, it would depend what. And again, if you go to a bank and explain why the structure has been done as it is, we've generally found banks are pretty willing to work with us on that front, because obviously you having more protection over your assets is better for them anyway. But I'm not entirely sure how to answer that. Sorry, Adrian. I mean, I guess it would depend on the person, depend on their relationship with that bank. But we haven't found it to be a problem with our clients. I mean, at the end of the day, they either control a trust which owns a lot of money, or they have the asset in their own name. Yeah, that's right. It's I guess the shortest way to say it is it's a little bit more complicated after the Royal Commission and COVID in terms of the bank asks more questions. However, it doesn't stop you borrowing in the future. You've just got to explain to the bank that this trust has a mortgage over the property, and then the bank will want a deed of priority which confirms that it goes first, so to speak. So generally not an issue. Mark's asked, if capital is contributed, couldn't this be called on, which is in relation to that earlier question. I mean, it couldn't be because it's contributed as a gift. So you could certainly, if you control the trustee, you could distribute to yourself, but you wouldn't in this sort of circumstance where you're trying to protect the assets. Yeah, and most trustees generally have clauses which automatically remove either a company director or an individual trustee as soon as they become bankrupt, automatically. Thanks, Helen. We'll close it off there. Michelle, as I mentioned, I'll come back to you on your query because there's a few questions we have to ask first because it depends on the state and so forth. I'd like to thank Helen for the presentation, and my apologies for the glitch with the handouts. It was fixed partway through the presentation, but if you didn't get the chance to download the slides, as I mentioned, they will be in the email that comes out with the feedback survey, so you'll be able to download it from them as well. I'd ask you please complete the feedback survey. We take it all on board. And with that, one of the things that we ask for is future topics or general comments. So always happy to present on what people consistently ask for. Our next webinar, which you will get invites for, will be on the 30th of June. Sorry, 30th of July. 30th of June is stuck in my head for obvious reasons. It'll be on Friday, 30th of July, and it will be the second part of this series, and we'll be looking at strategies for entities. This webinar is recorded and will be available via our website. Again, we'll let you know when that's available on the website, and we hope to see you again at the next webinar. Thank you.